The Supreme Court will now consider whether a state can put in place a Second Amendment Preservation Act with the purpose of making a state a two-way sanctuary state. However, the Trump administration has asked for even more time to consider what they want to do in this case, and they're pretty much now stalling out this issue. So let's break down what just happened. Now, before we jump into this video, if you guys want to support the channel for free, please consider subscribing to the channel. That helps the channel to grow. Also, just double check to make sure you haven't been unsubscribed, because YouTube loves to unsubscribe people. And then just drop a positive comment down below, because that helps tell the algorithm that you appreciate two-way content and should share it to more people. In this video, we're going to be talking about a very important Second Amendment protection case, which is once again back in front of the Supreme Court. This is a case dealing with a state's Second Amendment Preservation Act. We've discussed this case before because recently the Supreme Court issued an order denying a state which would have protected Missouri's SAPA law that they put in place. That is the Second Amendment Preservation Act that the state passed through their legislator. But now Missouri has filed their official petition for Supreme Court review. The Supreme Court will now consider whether or not they want to grant review to the Second Amendment SAPA case, but it appears that the Trump administration and the DOJ and Pam Bondi still cannot make up their mind about how they want to handle this case. It appears her office and their current strategy with this case is to delay essentially acting as long as possible. They put in place the new 2A task force, and in some of these other cases, like the range of felons in possession case, they decided to not challenge that, so they dropped that case and abandoned that case. But in this one, it seems like they don't know what to do, and they're trying to stall it out for as long as possible. Now, for those not familiar, back in 2021, Missouri passed a law called the Second Amendment Preservation Act, also known as SAPA. That law set the state's interpretation of the Second Amendment and set restrictions on the support and funding that the state would provide to federal agencies in their attempts to enforce inconsistent federal laws, which the state believed violates the Second Amendment. The law prohibits Missouri's officers, agents, and government officials from helping federal agents who are attempting to enforce those inconsistent laws which they believe violate the Second Amendment. The law also created a civil remedy where anyone can sue Missouri officials if they help to enforce federal laws which violate the Second Amendment. The Missouri law is similar in nature to the Texas abortion law SB 8 and the recent Supreme Court decision in the Whole Women's Health case. With the Texas and Missouri laws and how they're structured, you can't get an umbrella injunction against the state or the attorney general since they aren't the ones actually enforcing the law. Instead, it's private individuals through civil suits who are enforcing the law. In this Missouri case, the federal district court on review ruled in favor of the Biden administration, striking down the Missouri Preservation Act in its entirety. Now, in response, the state of Missouri then appealed up to the 8th Circuit. Missouri at that time wanted a stay on the lower court decision, but that was denied by the 8th Circuit, and then at that time, it was elevated to the Supreme Court on an emergency basis. Missouri wanted an emergency application for that stay. They wanted the stay to be put in place by the Supreme Court so they could still enforce their SAPA law. However, on review, the Supreme Court issued an 8-1 order denying that stay. Only Justice Thomas was in favor of granting the state of Missouri their stay to have their SAPA law still in force and effect. Now, after the Supreme Court issued that denial order, the case then went back down to the 8th Circuit for an expedited hearing and an expedited decision. The 8th Circuit ultimately did rule, they issued their decision, and they ruled in favor of the federal government, the Biden administration, striking down the SAPA law once again in its entirety. But now Missouri has filed their writ of cert to the Supreme Court, and they're seeking a final merits review on this issue. In the petition, Missouri presents three main questions for the Supreme Court to answer. First, can federal courts second-guess a state's reason for exercising 10th Amendment authority? Second, does the Constitution prohibit states from exercising 10th Amendment authority when motivated by concerns that a federal statute is unconstitutional? And finally, is a state official a proper defendant under Ex parte Young simply because the official is regulated by a statute, or does the official also need to possess authority to enforce the law? In this petition, Missouri goes on to argue that before this case, it appears no federal court had ever blocked a state from exercising 10th Amendment authority simply because of the reason the state expressed for exercising that authority. The 8th Circuit did that here, striking down a state law solely because the act said that the legislator believes certain federal statutes are unconstitutional. The 8th Circuit's holding creates multiple circuit splits, and it is wrong as it is unprecedented. It declared a Missouri law unconstitutional solely because of the law's legislative findings, specifically the legislator's opinion that some federal statutes are unconstitutional. The court took no issue with what the Missouri law does, only with what the legislative findings actually say. Indeed, the court agreed that the law with the same effect but different findings would be permissible. So one of the main things that Missouri is pointing out here in the cert petition to the Supreme Court is that the Eighth Circuit essentially said that the structure of the SAPA law is potentially, lawful in its operation, but the Eighth Circuit did not like the underlying Second Amendment purpose. They didn't like that it was built on constitutional issues revolving around the Second Amendment and fighting against federal laws which violate the Second Amendment. Missouri also argues that the Eighth Circuit went against clear precedent by finding that a state official could still be sued even though they didn't actually enforce the law. They found there the Eighth Circuit believed that non-enforcement is actual enforcement, that non-action is actual action, and they used that rationale to rule against the state of Missouri. Now, this law was directly opposed by the Biden administration and the Biden DOJ, but now the Trump administration has control of the government, and the DOJ and the AG's office in this case is now in their hands. Originally, the federal government was set to file the reply brief back in February, but they then received an extension. It went from February 26th and then was pushed out, I believe, 14 days. And then they got 30 days and then another 14 days. And now they're asking for even more time. The new motion from the DOJ states that the petition for a writ of certiorari in the above captioned case was filed on January 23rd, 2025. The response to the petition is now due after 3 extensions on April 25th, 2025. We respectfully request under Rule 30.4 of the Rules of this Court a further extension of time to and including May 26th, 2025, with which to file a response. This extension is necessary because the attorneys with the principal responsibility for preparation of the government's response have been heavily engaged with the press of previous assigned matters with proximate due dates. So once again, the Trump administration and the DOJ are asking for an extension of time in this case. This time, they are asking even beyond the 14 days, and they're asking for a 30-day extension. So the DOJ is likely going to get that new extension. Again, they're asking for 30 days every time they've asked for it, even though they didn't give a true rationale about, being pressed on other issues or, the DOJ's office and the new task force considering this, or maybe coming up with a new opinion on the SAPA laws. They don't really present any of that. They simply say, hey, we're so busy, we need 30 more days. Again, that's interesting because they just have a vague purpose for the request. And if they really wanted to, they could identify that, hey, we have this new two-way task force. The Solicitor General has changed. We are taking different positions in other cases. They could have a lot of other true rationales about maybe why they need an extension, but here they don't present any of that. It seems like they already know that they're going to be allowed to delay this case, potentially because the Supreme Court just simply doesn't want to really get involved in a lot of two-way issues right now. That seems to be kind of the mode that the Supreme Court is operating in right now. They have denied a lot of two-way cases, and they're also very inactive in other cases that are currently pending in front of them. We've seen that the Snope and Ocean State tactical cases have been relisted, 11 plus times. So, I don't think the Supreme Court has any issue with delaying or punting this case out for a later date. So now we're potentially going to have to wait until the end of May to finally get the DOJ's answer and response when it comes to the SAPA issue. I was hoping that potentially at the very least they would say we're not going to defend this, similar to what they said in the Range case recently, that, hey, we're just simply not going to defend this. We agree that potentially the SAPA law operates in a true way, in a Second Amendment way, and that the lower court got it wrong. Maybe they're not going to do that. I'm not sure, but it seems like at the very least, the DOJ and the AG's office strategy when it comes to the SAPA issue is to simply delay. Now, there's another wrinkle with this that could be coming into play, is the fact that the new Solicitor General was actually the one who at the lower court level, when he was still with the state of Missouri, was actually defending Missouri's SAPA law. Now, he has been recused from this case, so he's not going to get to defend the federal government. As the Solicitor General, he was recused. It's kind of in a footnote here on this recent order that he's recused because, of course, there would be a clear conflict where he could not fight for the federal government when at the lower court level, he was fighting for the state in favor of the SAPA law. At least that's how this operates, and he had to recuse himself. So that's another interesting wrinkle that could be coming into play here, and maybe they're having to get someone else spun up on this issue. So unfortunately, I think this is going to get delayed again, and it seems like the AG's office and the DOJ, and maybe even the new 2A task force, their strategy when it comes to the SAPA case is to avoid it for the foreseeable future. So we're going to keep our eyes on this to see how this develops. As we get more information, as we get more news, I'll let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.